This is Fox 5 News Morning.
Disney fighting allegations that illegally tracked children through its apps. A San Francisco mom filed a lawsuit last week claiming that the mobile games collect data later used for commercial purposes without the consent of a parent. The suit named several apps, including Disney Princess Palace Pets and Disney Emoji Blitz. Now, Phyllis Marcus is a partner with Hunton and Williams LLP, where she also counsels clients on compliance with the Children's Online Privacy Protection Act, COPA. Yes?
Right.
Okay. And she joins us now in studio with more. Good morning. This is right up your alley.
It is.
Is Disney at fault here if these allegations are true?
Let's not judge quite yet what is being alleged in the lawsuit. Disney put out a statement the other day that indicated that there might be something more to the story than initially meets the eye. They indicated that there might have been a fundamental misunderstanding by the people who brought the lawsuit of the law. That having been said, the law here is clear that if a website or an app, in this case directed to little kids, like the apps that are involved in this case, if they're collecting information, tracking information from young children for the purposes of advertising directly back to those children, they have to get parental permission first before they do that.
And so basically the problem here, before you say, well, what's the big deal, is that it can be sold to a third party. Is that correct in the most egregious cases?
That's right.
Okay. And just to read more of that statement that you alluded to there, Phyllis, basically they're just saying Disney has a robust COPA compliance program. We maintain strict data collection and use policies for Disney apps created for children and families. The complaint is based on a fundamental, as you said, misunderstanding of COPA principles, and we look forward to defending this action in court. So what might be the difference here? Might it have been the fine print?
It could have been the fine print, and that's one of the complicating factors for parents here. People ask all the time, well, what can I do to stop this? There is an obligation of parents to do what most of us don't want to do. We're busy, and we want to have our kids engaged.
And we think it's Disney.
That's right.
That should be the problem.
That's right. So you can do a little bit of prevention. You can't completely eliminate the problem, but if you take a look at the device that you give your child, there are some restrictions that you can apply before the child actually starts to play. As a child downloads a particular app, there's a lot of fine print to read, and it is a time stop. You might have to stop, hit the privacy policy, look through, determine what kinds of actions might be happening on the property. If none of those work, if there's no information that indicates that advertising is occurring or that they might be collecting, tracking information on your kid, then there is potentially a legal violation at hand.
Sometimes when you look at all the mumbo jumbo, I know you understand it, Phyllis, but I look at it and it's like, glaze, what is this saying here? Are there specific buzzwords or something that a parent needs to look for in the fine print before they hit, yes, I agree to the terms of use or what have you?
Well, there are certain big words to look at. We offer in-app purchases, for example. We track location. We work with partners to offer you enhanced advertising services. I mean, I could think up a whole bunch of legal terminology, and you really do have to stop and think as a parent, am I doing this for expediency, or is this an engaging game that I know about, whose practices I understand before I hand the device over to the child?
Back in, 2011, Disney had to pay out some big bucks for violating COPA. Do you think that the lessons were learned here? Would you be surprised if the lessons weren't learned?
I would be surprised if the lessons weren't learned. I was involved in that earlier matter. I was at the Federal Trade Commission at the time. It involved websites, not apps. Things have changed pretty significantly in the past 5 years or so in terms of children's engagement online. And what Disney has said in their public statement is that they do have a robust compliance program. That having been said, there have been a recent spate of cases. The FTC brought several cases a couple of years ago involving these very same practices. The New York Attorney General brought some major cases against big toy companies recently for the same kind of tracking behavior. So these are reminders that not just parents need, but also companies need.
In the seconds we have left together, tell us, what can a parent do I mean, you're going to be that parent that says, no, you can't have Disney's Pet Palace or whatever. What can we do? Can we opt out and still have a free app?
The problem is you can't pick and choose as a parent. You can't say, I want my child to engage with this particular app, even though I don't like some of the practices. And so you may have to be that parent who says no. You may have to read a little bit more, take a little bit more time before you give the device to the child. And these cases, even if it turns out that Disney wasn't quite doing what they're being alleged to have done, these cases are a reminder to the entire industry that they need to get their house in order and keep it in order.
Timeline here? When might we see a resolution in this?
It's not entirely clear because this is a private lawsuit, and so sometimes they go away without a big announcement. I would imagine that Disney is engaging right now in determining what might have happened.
Okay, Phyllis Marcus, thank you so much for joining us as always. All righty.